Welcome to Ocean Nexus webinar. This event is presented by the Nippon Foundation and Ocean Nexus. The Nippon Foundation is an international philanthropic organization with a mission to support social innovation and humanitarian effort, striving to realize society in which all people support one another. Ocean Nexus is a global network of scholars who conduct ocean-focused research with empathy, applying an anti-inequity approach that draws on anti-racist, anti-colonial, anti-patriarchy, and intersectional analyses. Our mission is to establish social equity as a central objective of ocean governance. We invite everyone interested in the issue of ocean equity to join us at the Ocean Equity Learning Forum, and the link to the forum will be posted in chat. So on March 4th, 2023, an international intergovernmental conference tasked to draft a new treaty on the conservation and sustainable use of marine biodiversity in areas beyond national jurisdiction, known as BBNJ, announced the adaptation of a new global agreement under the United Nations Convention on the Law of the Sea. This BBNJ treaty, representing 20 years of negotiation, established a new framework for ocean governance in the high seas. A year on, we will delve into question of its potentials and implications, its relationship with other relevant instruments and institutions, with a focus on Part 3 of the treaty dedicated to area-based management tool and marine protected area. Joining me to discuss this topic today are Jade Jones, an Ocean Nexus student fellow at the School of Law and Politics, Cardiff University, and Richard Caddell, leader in Marine and Environmental Law at the School of Law and Politics, Cardiff University, and a principal investigator for Ocean Nexus. My name is Wilf Swartz. I'm an associate professor at Marine Affairs Program, Dalhousie University, and the deputy director for Ocean Nexus. I'll be your moderator today. Today we will begin with a presentation from Jade. She will be presenting her work from a report released earlier this month titled The Scoping Report on High Seas Marine Protected Areas and BBNJ Treaty. A digital copy of this report can be found on the Ocean Equity Learning Forum or by the link posted in the chat. Thank you. Again, thank you all for joining us. And Jade, over to you.
Hi, everyone. Many thanks, Wilf, for the introduction and for moderating this webinar. I'm just going to attempt to share my screen so you can all see my slides. Okay. So yeah, I'd just like to take a moment at the start of this presentation to also express my thanks to Yoshi, Karen, and Ariel from Ocean Nexus for not only inviting me to participate today, but for facilitating this event and this space for the discussion. Also, my thanks to Richard for taking the time to discuss these themes with us. As Wilf mentioned, and as many of you will already be aware, we are in the midst of a truly exciting time in the law of the sea. The conclusion of negotiations for the new treaty on biodiversity beyond national jurisdictions, which from this point forward I'll be referring to as the BBNJ Treaty, marked a milestone moment. However, the time and space we find ourselves existing in at present, as we wait for the ratification and implementation of the BBNJ Treaty, also presents a unique opportunity, an opportunity for international legal observers to review the current legal framework, its inherent challenges, and consider both the potential of the BBNJ Treaty to resolve such challenges, and maybe more importantly, the likely limitations of the treaty. To aid this reflective exercise in today's session, I will provide an accessible overview of the current legal framework, particularly as it relates to the designation of spatial conservation measures in the area beyond national jurisdictions, the ABMJ. Towards the end of my presentation, I will look more closely at the BBNJ Treaty from Part 3 provisions on area-based management tools to the current status of the treaty and future steps and questions for its implementation. So to begin with, I thought it may be helpful for those who may be unfamiliar with ocean governance, just to provide a visual illustration and brief explanation of how ocean spaces are legally divided. Immediately, you can see from this diagram that legal divisions in the ocean are artificial. They do not correspond with biological realities of marine ecosystems. You have a series of zones which represent certain extents of sovereign state or coastal state powers and rights. For the purpose of today's discussion, the area beyond national jurisdiction starts from the 200 nautical mile mark. Importantly, the water column is considered separately from the seabed. Each have their own distinct regime within the ocean governance framework. The water column is referred to as the high seas, and the seabed is known as the area. Typically, the area also begins from the 200 nautical mile mark, unless a state has successfully applied for a continental shelf extension. An important aside to mention at this point, which has been discussed by other academics, is why I personally prefer to call the BBNJ Treaty the BBNJ Treaty as opposed to the High Seas Treaty, which has been a popular term used by the press and third sector. From a legal standpoint, the BBNJ Treaty will apply to both the water column and seabed, and to imply it's a High Seas Treaty is to an extent to undermine its potential application. This next slide is a really good illustration of the significant kind of coverage of the ABNJ. 2/3 of the world's oceans are the high seas. Once viewed as vast and featureless, we now know the ABNJ is bisected by a multitude of migratory corridors and biological hubs. The mid-ocean, below 200 meters, whose terrain is a similar merger of distinct water layers, is also home to many visually bizarre creatures with specialized adaptations to the unique environment, whilst the seabed, with its diverse topography of canyons, abyssal plains, seamounts, and hydrothermal vents, are the base of Lilliputian-esque benthic fauna, whose diversity rivals that of terrestrial rainforests. Thus, the considerable space between continents supports ecosystems of immense scientific, cultural, ecological, and economic value. However, the same technological advancements which fostered greater understanding of biodiversity beyond national jurisdictions have also facilitated opportunities to exploit and endanger. Images on this current slide present some of the major ecological stresses to international marine environments. Starting from the left, this image is supposed to represent pollution, and that's pollution in all its forms, not just the traditional understanding of pollution as vessel-based, but including things like land-based plastic contaminants. The second image is related to overfishing and also IUU fishing, and that's illegal, unreported and unregulated fishing. And then the final image is to represent climate change. But there are other significant threats, which can include things like acidification and invasive species. And so the preferred tools for addressing these ecological threats are currently area-based management tools, abbreviated to ABMTs, which include marine protected areas. In the upcoming slides, you'll see several examples of the existing application of such tools in the ABNJ, but first it's worth introducing some general definitions. ABMTs are tools or measures that are used to manage human activities in a particular area. They range from single sector tools such as fishery closures to comprehensive marine protected areas. Marine protected areas are considered to afford some of the highest levels of protection to designated spaces. In contrast to other ABMTs, their primary objective is conservation. Whilst other ABMTs may assist conservation objectives, it's not their primary utility. MPAs are comprehensive and offer multi-sector protections for cumulative impacts from various ecological stresses, including human activities and climate change. So the things that they cover and their purposes are much broader than specific ABMT measures. So having considered where we're looking to protect, why we're looking to protect, and how we'd like to protect, we then must turn to the current legal framework, and that is UNCLOS. So UNCLOS stands for the United Nations Convention on the Law of the Sea. It's an umbrella treaty. It provides a structural framework and high-level norms, and then the concrete details, the flesh to kind of the legal skeleton, is elaborated further by a patchwork of various hard and soft law provisions and separate institutions. And so the UNCLOS is a treaty that covers all activity in the ocean and all or regions of the ocean. So it will cover coastal, it will cover international. And therefore it's not a environmental protection specific treaty, but it does contain environmental protection provisions. And these provisions are largely within Part 12 of UNCLOS. So Article 192 establishes a general obligation that all states party to the convention are to protect and preserve the marine environment, irrespective of the jurisdictional zone. And therefore they're to protect and preserve the marine environment even in international spaces. And so the issue with international space is no one sovereign state is responsible. But yet Article 192 says that we all have this obligation to protect and preserve the environment there. Article 193 is an interesting one. It emphasizes that such an obligation is not an isolated policy goal, but must be pursued in tandem with the development of marine resources. And I see that really as an early precursor of the Sustainable Development Principle. We have to remember that UNCLOS was negotiated during the 1970s and therefore predates some of those environmental terms that came later on. Article 194, Section 5 of UNCLOS stipulates that measures pursuant to Part 12 shall include those necessary to protect and preserve rare or fragile ecosystems, as well as the habitat of depleted, threatened, or endangered species and other forms of life. But it's an important point that's missing here is that UNCLOS does not establish a specific legal basis for the designation of area-based management tools and MPAs in the area beyond national jurisdiction. Nowhere in there does it give the legal basis that would subject all parties to respect a high seas MPA. That's missing. And that's missing for a few different reasons. One of the first criticisms that can be made of Part 12 is the generality and vagueness of the language, which render the norms of environmental protection open to misapplication. And this isn't just a criticism that can be made of UNCLOS, but a criticism that can be made of most high-level multilateral treaties, that the language is general and vague in order to ensure that as many states as possible are able to negotiate and sign and ratify the treaty. So it's general and vague for a reason, in the hope that it'll then be ironed out at a later date. Another slight issue with Part 12 is that it is explicitly concerned with the prevention, reduction, and control of marine pollution. And that's largely symptomatic of the context in which UNCLOS was negotiated. However, such provisions do provide very little scope to limit kind of ecologically deleterious impacts of other maritime activities. However, there has been jurisprudence that has expanded the scope of Part 12, the Chagos arbitration and the South China Sea arbitration, so that measures are not strictly confined to marine pollution. Also, as of this year, there's the pending IPLC advisory opinion initiated by the Commission of Small Island States on Climate Change and International Law that will provide an important legal clarification on the scope of signatory state responsibility concerning climate change and ocean protection. Climate change was not a well-discussed environmental issue at the time of negotiation, and therefore reference to it is absent from UNCLOS. And so this advisory opinion is looking to further develop the Part 12 provisions in light of this new knowledge. Other tensions within UNCLOS include the freedom of the high seas regime. So Article 87 entrenches the freedom of high seas, and it's widely considered a central tenet of UNCLOS and of the law of the sea more generally. It dates back to antiquity. It effectively creates a common property regime in the high seas consisting of open access and the equal rights of users. It's this underlying regulatory philosophy of perpetual entitlement to communal use, which emerges from the freedom of seas, and that does obstruct the unilateral development of environmental protection measures, framing the designation of spatial conservation tools as creeping jurisdiction and giving credence to comparison with Hardin's Tragedy of the Commons. Other issues that arise due to the freedom of the high seas regime is the flag state freedoms, which are a part of that regime. And so on a vessel, for those who aren't familiar, any ship in international waters has to abide by the laws of the flag of the state that's flying on the vessel. However, we have seen flags of convenience begin to arise. We've also seen some kind of movie references to that as well. And that just means that environmental obligations are inconsistently enforced. You can have some states that apply very stringent environmental protection measures in the high seas and others that are more lax. And so it's inconsistent. You could have two vessels in the same area that has the same ecological vulnerability behaving very differently. And loopholes as well persist, which means that states can avoid all environmental obligations and sanctions in the ABNJ. But one of the biggest, I would say, problems with UNCLOS is the framework is very fragmented and very sector specific. The artificial legal jurisdictions and zones have given rise to multiple sector-specific institutions, and has meant we've really got this patchwork that Topfer characterizes really well as institutional misfit is the rule and not the exception in ocean governance. We've got a host of these bodies who, in absence of an overarching cooperation mechanism, operate largely independently of one another. As you can see from the diagram that I've tried to illustrate how UNCLOS kind of sits above this as an umbrella, and you have all of these bodies kind of operating beneath it, but there's nothing really linking them together. And so we've got the International Maritime Organization that regulates vessels and high sea water column issues. The International Seabed Authority, which is clues in the name, it's concerned with the seabed. Regional seas agreements are bilateral agreements between two or more states, and regional fishery management organizations deal with issues related to fisheries. Each of these bodies, in the absence of legal basis to set up conservation measures in the high seas, have seen examples of them trying to navigate that by, within their own competence, setting up their own types of ABMTs and MPAs, and we'll see from the coming slides where this works and where this doesn't work. So beginning with the International Maritime Organization. So this is a specialized UN agency responsible for the management of international shipping, including adverse ecological consequences of shipping. Interestingly, it predates UNCLOS and is one of the few intergovernmental organizations with a clear mandate to regulate human activities on the high seas. Even though the IMO predates UNCLOS, it operates within this umbrella framework. The two main instruments negotiated under the auspices of the IMO for area-based environmental protection measures include the International Convention for the Prevention of Pollution from Ships, that's shortened to MARPOL, and their special areas under MARPOL, and the designation of particularly sensitive sea areas. And so looking at MARPOL special areas and emission control areas, these broadly apply to all ships operating in marine environments. Provisions run across 5 annexes, so they can relate to oil, noxious liquids, substances, sewage, and garbage. So that's kind of the how they're applied. For enhanced protection of sea area designated as special areas or emission control areas. The designation of them is governed by scientific analysis that takes account of natural characteristics and types of fishing activities occurring in the area, but we have seen very limited application in the ABNJ. In terms of particularly sensitive sea areas, PSSAs, these are an area that needs special protection because of its significance for recognized ecological, socio-ecological, socioeconomic, or scientific attributes, where such attributes may be vulnerable to damage by international shipping activities. Significantly, these are designated by non-legally binding resolutions from the IMO Marine Environmental Protection Committee, and therefore they don't have an immediate effect until an associated protective measure is subsequently applied under a pre-existing interstate framework such as the International Convention for the Safety of Life at Sea. And you can begin to see it's getting very much a web of complexity here. Nevertheless, they are widely recognized. The widely recognized authority of the IMO does easily facilitate productive interstate conservation, but designation of PSSAs in the ABNJ are challenged by the prerequisite of a demonstrable link between risk of harm and shipping activity. And so, for example, it's very difficult to evidence and prove that a vessel in the ABNJ has caused harm to certain mammals. That evidence is hard to gather. They're also restricted to issues of maritime safety and shipping-related pollution, and therefore do not address other significant ecological stresses. And this is something that you'll see me reiterate across all the different sectoral bodies, is that they are confined to their own remit. And so the International Maritime Organization has no say over the area. And so we could have a MARPOL special area, and we can have a PSSA set up that would prevent certain activity, but then we could have certain harmful activity going on the seabed. It doesn't account for the reality of the biological oneness of ocean ecosystems. Moving on then to the International Seabed Authority. This acts on behalf of humanity to regulate the exploitation of minerals in the area. The intergovernmental body is also charged by UNCLOS with the development of measures to protect and conserve natural and biological resources of the area from the adverse impacts of mining-related activity. Its governing principle is the common heritage of mankind. This is interesting in itself, as it's different from the governing principle of the water column. So the water column is governed by high seas freedoms, the understanding that the ocean is open to all, and that everybody has a freedom to navigate and a freedom to exploit. Yet the area, the seabed, is governed by this common heritage of mankind, the understanding that it belongs to all of us, and so we're all responsible. Areas of particular environmental interest are the ISA's MPA ABMT workaround. So it's an area-based management tool designed to reduce or discontinue certain activities on a specified portion of the seabed, so closure of mining activities. Examples of it in application include the Clarion Clipper Zone. However, regulated activities limited to the exploration and exploitation of seabed resources. So once again, an area designated as an APEI and closed to mining can be subject to other harmful and exploitative activities, such as bottom fishing. So the seabed is shut for mining, but you can have on the same patch of seabed that's shut for mining, because of the vulnerability of the ecosystem there, will be subject to bottom fishing. It's a further example of the current framework creating weakness through arbitrary distinctions between equally destructive activities. Not only do we have these arbitrary distinctions between the water column and the seabed, between one patch of ocean and another patch of ocean, but even between one activity and another activity. This brings us on to regional sea agreements. So since the early 1970s, in recognition that no two seas are identical, an array of binding and non-binding regional sea agreements have engaged states in a collaborative protection of the unique offshore marine environments. Many of the binding RSAs have been introduced through the United Nations Environment Programme, UNEP, Regional Seas Programme, so UNEP's Regional Seas Programme, while others can be the result of independent agreements between regional partners. So far, 18 maritime regions are covered by RSAs, although as far as I'm aware, and I'm sure please correct me if I'm wrong, but only 4 of these include the area beyond national jurisdiction. So as we're moving through these examples, you can see that there is a slight hesitation to go into the ABNJ, and that's largely to do with this lack of a legal basis. It has the combined membership of UNEP and non-UNEP RSAs totaling approximately 95.5% of the world's states. So RSAs do account for a large portion of our ocean users. Generally, their mandate has expanded beyond vessel-based marine pollution to encompass wider transboundary biodiversity conservation concerns. In principle, this regional response tailored to each natural environment should surpass global protection requirements under UNCLOS. It should take them further and further the preservation of the relevant ecosystem. It is my opinion that the regional community is one of the best placed actors to identify the most significant sources of pollution and the most vulnerable marine biodiversity, while the joint stake in the geographic area ought to compel political consensus and promote straightforward environmental policy making. However, unfortunately, too often RSAs exhibit the same intrinsic dysfunction as the global framework: poor institutional coordination, insufficient funding for cooperative efforts, and weak enforcement mechanisms. The four RSAs covering the ABNJ include the Barcelona Convention, OSPAR, CAMLA, and the Sargasso Sea Alliance, and each in turn present an opportunity for extensive research and commentary. I have explored these in the report, which you're all welcome to have a gander at. But I think that the main takeaway from these is that despite some of the notable successes, we do see that instead of a holistic suite of environmental protection tools, again, we've got this patchwork of sometimes the sector-specific tools that are applied disjointedly and do end up leaving a good portion of the biodiversity vulnerable. Following this, we've got the regional fisheries management organisations. So these are related to fisheries. They've got a regulatory impetus to implement broader biodiversity conservation precisions pursuant to UNGA resolutions, but there are significant criticisms. Once again, it's a very narrow sectoral focus, and also their coverage remains spatially incomplete, meaning sections of the ABNJ lack a body to facilitate conservation measures. And so that brings us to the BBNJ and why the BBNJ offers such optimistic coming future, in that it's possible that the BBNJ could be the glue that we've been looking for. It could be a platform for collaboration and cooperation amongst all of these sectors, so that our patchwork is less disjointed and we're looking at a legal framework that's more effectively knitted together. For those who aren't too familiar with the BBNJ agreement, it is like a package suite, and so area-based management tools, including MPAs, are just one aspect of that. There are 3 others, but for the interests of this discussion, we'll just be looking at ABMTs. The treaty itself and the text of it covers exceptions, applications, objectives, proposals, decision-making, emergency measures, implementation, and monitoring and review. But that's a hallmark of these types of texts. We are looking at something that's still a little vague and a little woolly in areas, and hoping that these can be ironed out either by a preparatory committee or during the first conference of the parties. Something that I think is worth flagging to you all is that the exceptions is interesting. The exceptions include fisheries and it includes military activities. And so this really should be something that we're thinking about in this stage for as successful as the implementation of this treaty is going to be. How do we mitigate these exceptions? The treaty also covers proposals for area-based management tools and MPAs. It does so in a very broad sense, and this diagram here, taken from a recent report, gives a really clear overview of what the treaty is essentially saying and who the key players in that process would be, although we will need further information on kind of the definition of these players and how this will be in reality. Next steps. So the signature, it's open for signature. We've got 89 signatories, which is a really good indication of ratification. We need 60 states to ratify the treaty, and so 89 signatories. We're looking good. However, we're not quite there. It's not yet in force. We currently have 4 parties who have ratified the treaty as of this month. We also, from the recent European Parliament vote yesterday, that is looking good in terms of boosting for individual member states to accelerate state level ratification. Should the EU successfully ratify, in total, we'd have an additional 27 parties to the BBNJ Treaty, over halfway there. Other important updates in terms of the status of the treaty is the recent United Nations General Assembly vote. So that happened yesterday and today, where it was agreed that there'd be a preparatory commission prior to the first conference of the parties. And that will be a really interesting time for scholars to see what that commission has to say. It may give some indication on how this treaty may be implemented, but more so than that, it will help ensure that the implementation following ratification is as smooth as possible and as fast as possible. And that vote was actually 164 to 2 in favour. So it speaks to the support that's out there in the international community for the treaty. Several questions are facing the first conference of the parties related to funding and a host of other issues that I'm sure we'll all discuss in the Q&A. But yeah, that's where we're currently at. Much better than we were a month ago, but still some work to do. So I'm going to stop sharing my screen now and pass back over.
Thank you, Jade. That was wonderful. Thanks so much. Before I open the floor for questions, I'd like to take this opportunity to mention that we have several other Ocean Nexus research fellows whose areas of interest focus on issues of high seas governance. And so I had the chance to get in touch with them last week to ask some of the questions. So I'll begin by presenting these questions to Jade and Richard. Meanwhile, if you have any questions for our speakers, please enter them in the Q&A chat box, and we'll get to those questions after the few opening round of questions. So I'd like to start by asking about the potential implications of this new treaty in terms of equity. Jade?
Yeah, thanks. And so in terms of kind of equity in relation, particularly to area-based management tools and MPAs, I think the important consideration will be on participation, participation of Indigenous peoples and local communities, participation of regional voices that may be more marginalized in such a high-level state multilateral process. And so the treaty itself does make several references to the importance of traditional knowledge, and also in the proposal process, it references consultation with key stakeholders. But it will be interesting to see how this plays out in reality. And I think it's important to have these conversations now and air these early concerns and critiques so that we could possibly build this into the work of the preparatory committee and the work of the first conference of the parties.
Thanks so much. Richard, do you want to add to that?
Yes, certainly. I think one thing that's also quite encouraging is that the Law of the Sea itself has got a long history of trying to promote equity. And in fact, the development of the UN Convention on the Law of the Sea itself owes a lot to that sort of inherent rebalancing of arrangements. One of the real key drivers for this were, well, 2 key drivers for the initial UN Convention on the Law of the Sea, for which the BBNJ Agreement is an implementation agreement and expands upon and revises it. Firstly, one of the key elements behind this was on seabed resources and a desire in the 1960s to ensure equity of access to that, and that they were conserved for the benefit of humankind. I'm not going to do too much more on that because my colleague Edwin Agadi is a very senior member of the of the ISA's legal squadron, and can certainly address any further things on that if I'm not throwing him under the bus there. But secondly, one thing we really saw in the negotiations of UNCLOS itself was how big a role the developing states had, and about how this was an opportunity to recounter some of the more colonial viewpoints on the law of the sea that had sort of perpetuated through the 50s and 60s. And we really see that the UNCLOS itself is kind of driven by a lot of those considerations. And in the negotiation of the BBNJ agreement, we see that those same alliances coming to the fore again, you know, small island developing states grouping together as one to present a common voice, similarly with other regions and other shared interests. So I think we do have a sense of ocean equity being part of the philosophy of the BBNJ agreement, and as you see, it's going to be really important to retain that within the ethos of the COP as well. So hopefully that general philosophy permeates the life of the agreement as well as its sort of background and some of its wording.
Well, that's great to hear. Wonderful. So I'll move on to the next question, actually. So the next question concerns the relationship between this treaty and the Regional Fisheries Management Organization, the international bodies responsible for managing and conserving fish stocks in the high seas. Now, Jade, in your presentation, you mentioned that fishing is one of the exemptions that are noted in Part 3. But nevertheless, they have to coexist. And so how do you foresee this relationship evolving over the next decades, especially with respect to area-based management tool? Let's start with Richard.
Ooh, a nice easy one to start with. The political issues of RFMOs and the BBNJ agreements. I think it's worth going back a little bit in time to kind of answer that, sort of back to the future, really.
Okay.
And I think one thing that's really important to note about the BBNJ agreement was there was a real separation of church and state regarding biodiversity and fisheries. And there were a lot of good reasons behind that. There's already an implementation agreement for the law of the sea that deals with straddling and highly migratory stocks. And that really revamped the way in which we look at a lot of our RFMOs. So a lot of those RFMOs, that's regional fisheries management organizations that came into existence after 2001, when the fish stocks agreement entered into force, have been a lot more ecologically driven in their mandates and their mindset, which is good to see. And we've seen an element of rebalancing and retrofitting of pre-existing RFMOs as well in that. But there was a real divergence in views as to how we viewed fish within that. There was a lot of concern that, as we've seen in other forums like the Convention on Trade and Endangered Species, for instance, that there might be attempts to try to unpack and unpick fisheries entitlements by using environmental protections and other mechanisms by which to try to change things in that respect. And there's a lot of concern about how the politicized nature of fisheries allocations then perhaps undermining the progress in the BBNJ agreement itself, or towards the BBNJ agreement itself, and whether or not that was a good thing to bring in. So right at the start, there was quite a hard fought encounter as to whether or not fish would be part of the agreement, and it was decided that fisheries management would be left outside it. And we've had this sort of strange psychology in the negotiations of the BBNJ agreement that it's there to not undermine pre-existing institutions and arrangements. And in particular, they have RFMOs in mind in that respect. And the other point to that, and the counterpoint to that, is indeed Ocean Nexus research has revealed is that, well, of course, fish are biodiversity too, and that there's not just this sense of a biodiversity as a dolphin or something that looks nice and fluffy and that you're looking to protect. And that does raise a lot of concerns about whether or not RFMOs have that spatial and species-oriented approach that allows them to be more holistic about dealing with fish in the round and their impacts on the ecosystems, and in fact reveals that actually a lot of our RFMOs only deal with a very small number of species. So a lot of fish and other biodiversity related in that context could potentially slip through the gaps. So clearly from the outset, the BBNJ agreement is dealing with biodiversity, but some biodiversity is more equal than others, to paraphrase George Orwell's phrase in a fisheries context there, really. So yeah, I think that sense of a wall between fisheries and biodiversity conservation that's apparent in a lot of our international organizations will still be apparent here, unfortunately. And the COP will, I think, have an important role to play in trying to break that down a little bit. But yeah, I think it's about making sure that each other's pieces of the puzzle is heard and taken into consideration in decision-making processes.
Thank you, Jade. Do you want to add to this, or?
I think the only comments I would add is just to bear in mind two things really: the flexibility of area-based management tools and MPAs. You can get seasonal MPAs, and this may make them more amenable to kind of collaboration with RFMOs, and also the fact that these regional sea agreements do have existing cooperation with RFMOs in certain areas because of regional overlap and regional relationship building, and therefore it does also come down to how the BBNJ is implemented and at what level may promote more effective collaboration with one another.
Thanks so much. I'll move on to my last question. When we talk about high seas closure in terms of fisheries, the classic case that we always learn about is the Bering Sea donut hole and the closure of the donut hole in 94, and more recently the moratorium on fishing in the Arctic. These agreements were mostly spearheaded by powerful, states, coastal states surrounding these regions, notably the United States and Russia. And so it was more like, kind of felt like more unilateral than international. And now that we have this international framework where all countries is involved in the decision making, how do you feel like this type of closure approach, this type of coastal nations imposing closure donut holes, how is that going to work under the BBNJ Treaty?
I'm not sure that it will. And I think the closure side of things is a really, really interesting case study. And it's actually quite a positive case study to my view, particularly the Central Arctic Ocean aspect of things. And for those that aren't sort of obsessive Arctic fisheries geeks, which I imagine there's quite a few, just by way of background on this, the idea of the Central Arctic Ocean's closure is to regulate a future fishing in this area. And it's actually a really rare example of far-sighted preemptive regulation, because the idea, of course, is we're seeing climate change, and we're also seeing the movement of fish steadily polewards, either towards Antarctica, or the models seem to be projecting consistently there will be a great northerly movement of fish. And there's still a lot of scientific and other biological issues around whether or not all of these fish will suddenly empty out from the tropics and suddenly relocate to the Arctic. And there's still some issues on barriers and elements of that a lawyer can't hope to explain properly, but I suspect we'll see in a future Nexus webinar. But what the CAO Central Arctic Ocean elements have done is they've realized that this is going to happen at some stage, and that they would be essentially moving into unregulated waters. So what we've seen before, and Jade mentioned the tragedy of the commons and other elements of that, is that once the genie's out of the bottle with fisheries regulation, you can't get it back in. So once states have become used to being able to claim X amount of fish, it's very, very hard for them to get them to accept a lower level. So what's happening with the Central Arctic Ocean is that we're entering into a preemptive regulation. So it's regulating a stock that isn't there yet. And it's regulating a fishery that can't fish in those waters yet. So the idea is that it'll do this in a very, very precautionary manner, starting off with research fishing and exploratory fishing. And then once they've worked out the impacts on the ecosystem, following a model that they've pioneered in Antarctic fisheries, then we'll start to see a little bit more control or a little bit less control of this and more in the sense of commercial quotas, so that we start to regulate that fishery right from the very start in a very sustainable, very controlled and very coordinated way. So not all fisheries closures are bad closures. And where, of course, there's always winners and losers, and there's always concerns over unilateralism versus multilateralism in these sorts of arrangements. There is a very strong ethos of instituting protections and a degree of responsibility to the fishery that hasn't characterized fisheries management on an international scale before. And I think it's quite a rare example of very far-sighted management in the face of climate change. And I think there will be some tricky issues to iron out. At the moment, there is a bit of a cartel mentality to who can be party to that arrangement. There are 10 fishing entities that are essentially going to be taking the main seat at the table in that respect. And fisheries management organizations have not generally been welcoming to new entrants. So there will be elements that iron out from that. But I think this idea of how we regulate these large expanses of space, that we will get lessons in from the experience of the BBNJ, might stand us in good stead to see how those will coexist. But yeah, just I think to point out that fisheries closures aren't always a bad thing, and trying to institute fisheries closures when you've got communities that are reliant on those quotas will have a much more detrimental effect on human beings and equity than actually giving everybody that fair slice of the pie to start with, and then increasing their rations as we go on.
Well, thanks so much, Jade.
Yeah, I think all I would add is perhaps it strays a little bit from the question, but in light of kind of what Richard's just discussed, is the BBNJ Treaty as well. The philosophy and the governing principles of the BBNJ includes both common heritage of mankind and the freedom of the high seas regime. So it'll be interesting to see how these closures reflect both of those. Just something else, I suppose, to be ironed out at a later date.
Thank you both. Now I'd like to open the floor. I'd like to invite questions from our audience. We have one actually, so I'll start with that. This is a question from Chris McCowan. He's saying that I was wondering how you thought IPLC Indigenous people and local communities would engage in this process. How traditional knowledge will be accounted for. For Bolivia, for example, which is landlocked state, but which places great emphasis on the value of Mother Earth, how would they be able to show that they are a stakeholder, particularly noting that they are to be consulted under Article 19, but not involved in the decision-making, Article 23, regarding ABMTs. Do you worry that they will struggle to make their case, as it doesn't have a clear, doesn't have a direct clear on how this will impact them and their claim to something thousands of kilometers away?
I'm happy to take a first pass at that if you like. So yeah, a great question. Thanks, Chris. Typically incisive and fiendish. So that's a really interesting point. I think from a legal perspective, we're getting very good about putting this kind of wording into treaties, and it's not new wording. Sort of goes back to Principle 10 of the Rio Declaration back 30 years ago now, about trying to build in greater degrees of participation. And I think it's fair to say that the institutions of the of ocean governance and the law of the sea have not enjoyed a reputation for transparency. We've seen that a lot of criticisms of that of previous bodies, IMO, ISA to an extent, RFMOs, and other bodies such as that. So it's interesting to see that in the BBNJ agreement, there is a provision in there that creates an obligation towards transparency, and it's largely copy-pasted from the UN Fish Stocks Agreement in that respect. And we start to see that becoming part of the work of these various institutions. But I think, as I said, we're very good at sort of putting them into the treaty and saying, there, we've done that, without necessarily operationalizing these in a particularly clear and coherent way. And there are some good examples of how this operates in practice. We have the Aarhus Convention on participation. We have a new agreement in Latin America, the Escazú Agreement, that again tries to bring communities into environmental decision making as a central human rights aspect of things. I think this is one of those big questions that is going to need to be ironed out in the formation of the COP. And I do have a degree of concern that the IPLC issue does kind of fall into a little bit of box ticking sometimes, where there's international discussions and international instruments, and there's a sense of, well, we've done it. But as we see in a lot of different forums, getting people the opportunity to speak and to actually make their voices heard properly can be quite a challenge in respect. So I think the development of a PrepCom is to be warmly welcomed on that, to try to push this. But I have to say that we don't have huge bundles of examples of where this has been operationalized in a very, very clear and coherent manner within large international forums of this nature. We see it in aspects of things such as Indigenous co-management and local communities getting involved in rather smaller scale institutions. But I think rolling this out on a wider basis is not something necessarily that international law has covered itself in glory with from a methodological and operational perspective. And I do worry sometimes that these things are put into the convention to tick an Aarhus box and to tick a direction of travel box in these things. But there are examples of places like the Arctic Council, for instance, where Indigenous people have a distinct place at the table. And that's probably, I suspect Jade's going to, had that in her mind there, she can shed a bit further light on that. But I think that's probably the best example of where we see traditional knowledge and Indigenous people actually having that enhanced seat at the table.
Jade?
Yeah, I completely agree. I actually love that question because I haven't actually ever framed it in that way before. But not much to add to Richard's response, but only the fact that I take a slightly more optimistic view on how IPLCs will be incorporated into the process. And I also think that to an extent, in a way, there shouldn't be a differentiation between those coastal-based IPLCs and landlocked-based IPLCs, because if we can champion their role and voice as IPLCs, we've overcome an obstacle, a huge obstacle in one sense. So I think how IPLCs are treated will be important moving forward, and will be important to see from the COP. But I think that the existence of the Arctic Council and the role of IPLCs in the Arctic Council, it can work. It just needs to be scaled up, and I truly believe that that's possible.
Great. Well, I think on this very optimistic note, I think that's where this is a great place to end our seminar. Thank you again for both our speakers, Jade Jones and Richard Caddell. I really enjoyed this. Yeah. Next month, the Ocean Nexus webinar will tackle the question of a blue economy in a changing world through conversation with Dr. Pedro Gonzalez Espinosa and Andres Cisneros Montemayor of the School of Marine and Environmental Studies at Simon Fraser University. Hope you can join us. Thank you. Thank you again for joining us today, and hope to see you again next month.